Friends, as we near the second century, hitting the second century, because today we are on the 196th session. And as the journey continues, we have been exposed to different thoughts, ideas, and subjects. Today we are on a subject with which in the last 95 sessions we are not dealt with. It is very important because more you try to understand, less you understand about it. When you ask, is it complicated? You can make it complicated. Today we have a judgment from our High Court wherein a pillion rider not wearing a helmet may not be construed as a contributory negligence as to void insurance, is what I just read. Today, thanks to Justice Somayajulu sir, we have a wonderful speaker, Sri.N. Vijayaraghavan sir from the Madras High Court. And we are privileged with the presence of Justice V. Ramkumar sir, Justice Ramakrishnan sir, and all of you wonderful participants. And let us make this Saturday evening worthwhile by listening to the speaker. This being a thoroughly informal platform where we don't waste time on anything else other than discussions, deliberations, and exchange of thoughts. Directly over to you, Vijayaraghavan sir.
Yeah. I take the clue and straight away would say only good evening to all the friends. But the scary exchanges you made prior to it makes it a tough call for me because we live in pandemic times. And a gentleman judge has introduced a viral infection to inflict you on a Saturday evening. I hope you all have a vaccine at hand, which is an exit option. I will perfectly understand whoever exercises the vaccine and gets out, not wanting to get into the viral infection that may have inflicted on you. Now, straight away, I would like to talk about something about the hybrid nature of the proceedings that we are now conducting in court and the kind of webinars that we are now getting used to. See, I had occasion to watch the release of Tyranny of Merit, a book by Michael Sandel, Harvard-based professor who is very famous for his justice lectures. And I also had occasion to visit the the release of book of Adam Grant, a Stanford professor, organizational psychologist, Think Again. All these things. And day before yesterday, I had occasion to listen to a live debate between Daniel Kahneman, who is the Nobel laureate and a brain scientist, and Yuval Noah Harari, the Hebrew University professor, author of Sapiens and Homo Deus. Now, all these opportunities will be lost because the legal fraternity does not seem to be comfortable with the hybrid nature because they seem to have assumed that it's only the elite nature of people like us who have made some grade in the profession are having access to justice and rest of them are left behind. It's not associations which are having some kind of an infrastructure to provide a room or a cubicle with a laptop where access can be given to the junior advocates, which I suggested to the SCE committee also, and they have said that is not a bad idea. We will recommend to that. That we have recommended because in our office, we have opened up a few laptops and allowed it to be used by people who don't have access to that. That's how we get access to. Why do I say it is important at this stage? Because it was during this pandemic, I realized the importance of the technology platform that we are having. A huge gift. Work from home is now a huge bonanza. I don't want to miss it out. I don't want it to be dissipated in any manner. I would urge every participant to carry this message wherever he can and see that the hybrid platform at least is strengthened and it becomes a reality forever. Now, before Justice Anand Venkatesh, we had an occasion during the May 2020, the initial period when we went into a complete lockdown. Judiciary also was in a complete lockdown. Thankfully, this gentleman judge, like Justice Somayajulu, another gentleman judge, not an oxymoron and a true gentleman judge, both of them, I had occasion to bring up a huge spate of 221 motor accident claims before worth about 13 crores of rupees. All these Instagram, SMSs, emails on this platform. And the persons who are settling these claims also came on record live video base and accorded their sanction and the settlements were made. And there was a huge report about this in many newspapers about what Anand Venkatesh had done, that he had immunized the pandemic impact on his court. Like that, there were so many articles. But the tragic fallout of that, I would urge each one of you to go to an article which was recently written in print by a journalist, Apurva, who happens to be a lawyer, on what happened during the proceedings. And she has written a profile about Justice Anand Venkatesh. In that, she records this fact. Out of 25 high courts, only Madras High Court has barred, prohibited specifically settlement of motor accidents claims on Lok Adalat. Only Madras High Court, and in its video conferencing rules 2020. Rest of all the high courts have either enabled or not prohibited. Now, I don't want to talk about that. It's a very sensitive story, which I shall refrain from. I would recommend you to read that Apurva's article. You may get the hidden message or the hidden reasons for what has happened now. It is really most disappointing that I belong to an institution where they are barred after a huge success which has been demonstrated for that. Now, coming to the topic, which is a very rare thing for a lawyer to come to when he's asked to address an audience, such an erudite audience like this. When I come to that, the first thing that strikes me is an overview of the compulsory motor insurance. I will go to the first day in office. For me, as a motor accidents claims lawyer or a lawyer who was practicing in an office where the senior was on the panel of many insurance companies. Besides, he was a real Jambavan. Yeah, I don't know how many of you know about him. He was S. Sampath Kumar, senior advocate. For a brief period, he was also appointed as an additional solicitor general when Mr. Jana Krishnamurthy, BJP, for the first time was the law minister. And thereafter, he lost his office. My senior also lost his office alongside or consequentially. Now, Mr. S. Sampath Kumar and myself were entering, because I would like to make it as anecdotal as possible. Motor insurance basically is a dry subject where only money moolah is involved, only blood, toil, tears, or death victims, like talking about the COVID impact in the whole nation. That alone, people assume it is only all about all these things and there is no law or no insurance or no constitutional issues or nuances or intricacies that need to be gone into. Only kind of people who don't is the premise. For instance, all of us know those who practice in motor accidents claims are more often than not called by the pejorative ambulance chasers. Now, when I was studying about all these things, you know, he is the one who defended O.J. Simpson, the footballer, and rescued and got him an acquittal after he was found to have killed his ex-girlfriend and her present boyfriend, according to their own culture. Now, F. said, it's very shameful, sir, because I am not an ambulance chaser. I am mostly there before the ambulance. That is what he said. That is the status after the Bhopal gas tragedy also. We saw the impact of the Americans coming and invading India like a swarm of bees and trying to catch victims for filing cases. That is how it is. Now, when I was entering the motor accidents claims tribunal, Chief Court Small Cases in Chennai, it's a lovely heritage building. Anybody who comes to Madras High Court campus should visit that. One of the finest heritage buildings of the court offices or the premises you can have. We were entering the court hall. There was the judge presiding was Justice David Christian. He was one of the finest common sense judges I've ever seen in my life. He was not a constitutionalist. He was not a legal scholar. He was not an expert, but robust common sense, which enabled him to solve matters and not necessarily decide cases. There is a huge difference between Lord Denning and Antonin Scalia used to say there's a huge difference between solving a problem and resolving a case. The two are totally different. Antonin Scalia, the Supreme Court always said, in the Supreme Court, I have no concern about who wins or who loses. It is for me to settle the law for the entire nation. I don't care a damn who wins or who loses. That is not how law should permeate at the lower level. Now we were entering the motor accidents claims tribunal. I was entering with my senior, and he always had this small Bhagavad Gita book on his hand. He never wasted his time. He used to tell me, instead of reading the law books while in practice, better to read this because salvation is sure through this route than that route. So he used to read Bhagavad Gita. We both were entering the court halls, chief court, small classes. We saw a small assembly of people, 4 or 5 people standing there. And there was a lady who was well dressed, and she was a married lady. She had a kumkum on her forehead, and she was also having a Mangal Sutra. We saw she was also having a lot of jewels, and she was standing next to somebody who was also a well-dressed gentleman. But there was a lawyer also who was standing, and they were trying to persuade that lady to do something. And that lady was shedding tears. This was the scene with which we entered the court hall. When we went into the court hall, Justice David Christian always obliged our office. First chance he used to give us to decide cases, because we will quickly resolve the case and walk out. We did not have time to waste in court. He knew. He also had no time to waste. So he used to take our cases first. As we entered, my senior went into the well of the court. Then he said, I would like to say something to this court. The judge said, why is it, Mr. Sampath Kumar, you should come to the well of the house? I would have come down and listened to you as such a senior member of the bar. I want to hear. Now he said, I have something very sensitive to say to the court, but I would like the court to cooperate in solving the problem, which I think is happening outside the court. Now he said, he asked the judge, please go and ask the officer, the court assistant, to go and bring the 4 or 5 people who are talking to each other. Please ask them to bring. It is my apprehension that the claim has been filed by a widow for the death of her husband with a child, with a minor child, which I am about to take and try before this court. Now, what I understand from what was going on, if my hunch and gut feeling are correct, she had remarried during the pendency of the proceedings, but the claimants and those who were assisting her and the advocate were persuading her to take up the role of a widow all over again in the witness box, so that she can show that she was a widow and not a remarried person, so that the compensation or the just compensation she may get is not reduced. Now the judge is a robust common sense gentleman. He is also a furious. When he gets angry, he really gets angry. He really lets arrows fly. No bars, no innuendos will be there. He will use vernacular language which is understandable to the ordinary man. And he was very good. He had a fantastic vocabulary in the vernacular, in abusive language in particular. Now he called these people inside. They came in. Then he pointed out to the well-dressed gentleman and got him and asked him to get into the witness box. He asked his name. I still remember the name. He said, my name is Manoharan. He said, why have you come? What for you have come? He said, my sister-in-law has filed a claim for herself and her son and her minor son. I have come for that claim. I have come to assist them. Now, who is your sister-in-law? He said, her name is Sakuntala. Then he asked that this gentleman, he asked him, what is the name of the husband of your sister-in-law? He said, it's my brother so-and-so. He said, Anantan or something. I don't remember that name, because this gentleman I clearly remember, Anand. Then he said, then he looked at that lady, the young lady, and called her, asked her to get into the witness box, and asked her straight, point blank, Madam, are you remarried after the death of your husband? She said, yes, I am remarried. Now, why are you not having your kumkum, and why is your Mangal Sutra hidden inside your blouse? He asked her. She said, I was told, otherwise the compensation that is payable will come down, and my child will lose the benefit of the compensation, which is a huge protection to the family. And therefore, I was asked to play the role of a widow all over again in the witness box. Really, David Christian took it out on the gentleman, but my senior intervened and said, Your Honor, let me intervene here. Now, it is very clear that these people are thinking that they can get the compensation that they deserve by setting up a story as if she was not widowed. Now, I am going to tell your lordship that you need not reduce 1 rupee from the compensation that is payable to the family because she is remarried. I will not post one question about the remarriage. I will not cross-examine her that she has got remarried or even put a suggestion that she is remarried. What I would request the court to do is compute the compensation that is exactly payable, give only a minor portion to the major claimant, the widow, who is remarried, make the entire award that is payable in the name of the minor and not to be withdrawn until she becomes a major and only periodical interest of 6 months. The judge really got furious, even more furious after that, and he turned around and said, see the gentlemanly and diplomatic and wonderful and chivalrous and generous manner in which they are addressing the issue and the manner in which you have stooped and the low level to which you have stooped. Now, why I am illustrating with this story is to suggest that motor insurance claim, either one side is trying to show that all is wrong and they need far more than what they deserve. And the other side, the insurance company, is trying to beat down the claim completely. Now, my urge, my endeavor during and in my books also, what I have written is, there is what is called as a middle path. There is no black or white. There is always a gray. Please stick to the gray path. See if you can find out if you can do justice in spite of law. In spite of law. That is what Lord Denning in that famous Brown case, he wrote that I will do justice in spite of law. In his Talking Justice book, Antonin Scalia takes him out and says, what kind of a judge is this gentleman who says he will do justice in spite of law? Now, that is the nature of motor insurance thing that should come. And why people are doing that, I will give the other side of the story. There are two reported judgments. I am not going to identify the references. I will only tell you these are two reported judgments. One from Punjab and Haryana. 3 girls. Now, Mr. Shyam was also pointing out about the non-wearing of the helmet and the contributory negligence, no contributory negligence finding by Kerala High Court today or whatever. It may be useful in that context. Now, 3 girls, all spinsters, they were traveling on a scooter. They were hit by a lorry. 3 claims were made by parents of the deceased girls seeking just compensation in the court. Now, the argument advanced by the public sector insurance company in the counter, I saw that counter. It is there in that counter. It clearly said, all 3 girls are spinsters. We live in India. Punjab and Haryana is also known for the dowry difficulties that the parents of the girls face. Now, by reason of the death of the 3 girls, the parents have been rid of a huge expense that they may have been forced to incur if the girls were alive and they had to marry them off. By reason of this, the dependency of the girls on the family should be construed in a far less manner. Now, you should take of compensation to be accused that your girls, death of your girls is much better for you. You are much better off now than before. Cruel, absolutely cruel. But the learned judge did not deal with it in a manner it ought to have been done. In another case, I will give you Rajasthan. A 23-year-old gentleman lost his leg. He was amputated for about 70% disability or whatever. Now, the insurance company in that case, that is also a reported case, if I remember right, the judgment was given by Justice G.M. Lodha, who was the Chief Justice of the Rajasthan High Court. I'm not going to identify the cause title. Now, I will only give you this much of reference. Now, in that case, the insurance company took the stand. This, the fellow who has been suffered an amputation is now physically handicapped to the extent of 70%, which enables him to get employment in the government quota under the handicap category. And therefore, the compensation that should be payable should be balanced against this aspect, that he is now better off in being in a better position to get an employment in the government. Now imagine the plight of the people who are filing such claims. And this is why in that very judgment, if I remember right, G.M. Lodha uses the word Shylockian. The insurance company has behaved in a Shylockian manner. That is what the insurance companies are generally perceived to be unreasonable. The reason is because of the attitude that has been, and more importantly, I will tell you, when the insurance companies project as defenses, who is responsible for those defenses? Don't tell me the insurance company general manager or the manager or the assistant manager does a lot of thinking in his chamber and comes and gives the brief or instructions to the lawyer to say, the lawyer thinking on his own, thinking that he can be better, more loyal than the king. He's inventing all these excuses and putting it there, by reason of which he is getting the name that the insurance companies are unreasonable, cruel, Shylockian, and whatnot. So my first endeavor will be to suggest that the motor insurance portfolio, being a compulsory motor insurance portfolio, for that you go to the first judgment which is reported in AR 1959 SC 1331, British General Insurance Company versus Captain Idbar Singh. You know who are the kind of what caliber of persons who argued for insurance company? It was MC Settleward who argued for the insurance company in that case. He put forward the proposition that under 90, see, the whole motor vehicles Act as stands today, be it 1988 or the one that has been amended by Motor Vehicles Act, thoroughly overhauls the existing 11 chapter, but still not been notified. I don't know whether the pandemic is the reason for that. It has not been notified. Road Traffic Act 1930 of England. The problem in motor insurance is people are bothered about money. People file a claim. It's like a fixed deposit. You get a compensation. You get a huge share. You have a chamber fee. You have a contingency fee. You walk off with that. See, recently, as and when, see, one thing I will make it very clear. I was just listening to Eric Weinstein, a set of people. Don't prepare yourself, because the brain has a knack of going in the linear way. If you prepare yourself, it will go in the same way. Whereas your memory will trigger all those thoughts and the anecdotes and incidents which are all in the back of your mind, and they will start coming out. That is what the brain coach Jim Quick. I will advise and recommend each one of you to go into the YouTube lectures of Jim Quick, Jimkwik. He's a brain coach. He really advises how, see, people used to admire my memory as elephantine. Nothing, it's not a big thing at all. It's simple because I was greatly fascinated by cricket. 1932 Bodyline series, if you ask, first test he was ill, no injured, did not play. What happened? Second test, what happened to Stan Makeup? How much every single 97 not out that G.R. Vishwanath played in Chepauk. I can tell you what was the 95 to 97, how did he go? Or 35, all that has gone into my memory because I have a passion for it. If you have a passion for something you are doing, then it will automatically. My passion was not for motor insurance. My passion was for law. For a larger purpose, I try to serve. I try to serve even today. That is why I try to recall all these incidents. Now, going back to AR 1959 SC 1331, based on Road Traffic Act 1930, our 1939 Act was framed. Now, nobody in India, even today, even the Supreme Court has not read it. That is my concern and really anguish. Section 95, subclause 1. In pari materia with Motor Vehicles Act 1988, subclause 1, 149, subclause 1, 88. If you come to Act 32 of 2019, which may be notified one day, God only knows, Chapter 10, it will be 150, subclause 1. Now look at that provision very carefully. Even today in Singapore, Hong Kong, or any other British territory, this law is the same. It continues to be same. What does it say? It says, a claim needs to be filed only against the owner of the vehicle, not necessary to file against the insurance company at all. The award can be obtained against the owner, and the owner, after the award, he has to carry it to the insurance company and tell them, I contested the case, I lost it, whatever this has happened, an award has been passed. I have an insurance policy with you. You please play the award on my behalf. That means the owner, if he concedes most of the facts, he can even get an award straight away and pass it on to the insurance company. It is akin to Section 10 of WC Act, where the employer himself makes a representation about the occurrence of accident and admits all the claim. And Section 10 award is passed straight away against the employer, which the insurer has to indemnify if there are no defenses. Similar to that, 149(1) is there. Now, one fallout of the failure to identify this fact is you go to Section 170 Motor Vehicles Act 1988, which requires an insurance company to file a petition to seek permission to contest the claim on all grounds that are available to the owner. The whole misreading of this provision, these two provisions has come because 95(1) has not been properly understood. By reason of which, there are, at least in my book of 2 volumes, Motor Vehicles Laws, Butterworth, LexisNexis, which I wrote with Justice Kannan the day he became a judge on 31/7/2008, the 13th edition. Now it's running in the 16th edition, 2 volumes. It's about 4,000 pages. I have counted at least 183 judgments of on 170 alone, which are all absolutely unnecessary, totally OTOs and meaningless, simply because if 149(1) or 95(1) as it stood previously, or what it will stand under 150 after Act 32 of 2019 comes into being, what it means is the claim is required to be filed only against the owner, and insurance company is not a necessary party. Is not a necessary party. But 170 says, if the insurer wants to contest the proceedings by finding out that the owner was colluding or conspiring with the owner, they can seek impleadment, and please note the expression in 170. Upon impleadment, impleadment is a condition precedent for me to get the benefit or requirement of Section 170 Motor Vehicles Act. If I am already impleaded as a party, as happens in every single case in India now, there are no claims filed by anybody without impleading the insurance company. If the insurance company is already impleaded and the owner of the vehicle remains ex parte, where is the need for the insurance company to file a petition under Section 170, which is all 99% of the time, it is only an administrative work. Everybody says notice taken, no objection allowed. The judge has to pass an order. And in Sankaraya judgment, the Supreme Court said, no, you cannot simply say allowed, you have to pass a meaningful speaking order. Now there is a speaking order that is being made for a totally unnecessary petition. Now I have been crying my crying horse since 1992, if I remember right, 1992, 1 MLJ 41, which I did before Justice V. Ratnam and Justice T. Somasundaram. You know what? He called me into the chamber. He was a very, very good friend of mine. He passed away last year due to COVID. He was around 92 or 93, son of the great A.V. Viswanatha Sastry, wonderful Chief Justice of Andhra Pradesh High Court. He went on to Supreme Court till the last day of his life. He went by a rickshaw to the Supreme Court to practice as a senior advocate, one of the finest senior advocates in the tax jurisdiction. Now, Justice Ratnam called me inside his chamber and told me, I have read whatever you have said about this 100, the equivalent of 170 was 110C 2 capital A. He told me what you say is perfect logic. What you say is perfectly right. But you are a lawyer. I am a judge. I am worried about the pendency. I am able to dismiss 101 cases because 110C 2A has not been filed. I'm going to list next week about 250 cases and dismiss them in one go on the ground this petition has not been filed. Don't try to harm the interest of the court because you will be contributing to the lowering of the pendency. Now tell me whether there was any law here or anything like that. Nothing. Now coming back again to Captain Idbar Singh, what MC Settlebat argued was the insurance company has been told that they can have only these defenses and no other defense. Now, that is the restricting. It is a restriction on the fundamental right of an insurer to contest the case with all the legal rights they otherwise have. Now, what the Supreme Court did was they went into the history of that legislation and found out the purpose with which compulsory motor insurance was issued was not to enable the insurance companies to run their business on profitable or economical lines, but for the claimant to be protected because the owners of the vehicles may be men of straw. This is the expression that Supreme Court used. That Supreme Court proposition was adopted only much later in 1987 ACJ 411. If I remember right, Skandia Insurance versus Kokila Ben Chandravardhan. That is a beautiful judgment where they again went, that was a case where the driver was driving the vehicle without a driving license. And you know who argued that case for the insurance company? Mr. Soli Sorabji, the senior advocate. Some of the finest senior, it's a real tragedy. I need to say this because some time ago I had occasion to preside over a meeting of enrollment of advocates, about 250 or 300 of them in the Madras. I got the bar council asked me to come and preside and address them. So I addressed them, inspiring talk, all that I made. At the end of the talk, I came down. I wanted to accost some of the children who were getting enrolled as lawyers. I pulled out about 5 or 6 of them and I asked them. The first girl I called and asked, what do you intend to do? She said, my father is a policeman. He has already got hold of a few cases. He has told me all that I need to do is get us enrolled as an advocate. He will give me cases. He will finance litigation. We can make money in the motor accident jurisdiction. The other one I asked, he said, my father is working in a hospital. He has immediate contact with the policeman. He can catch cases. 5 or 6 of them out of 20 I had an interview with told me they were all entering into motor accidents claims because they don't need to know law. They only need to have a suitcase full of money for financing the litigation. You have to pay. It's a well-oiled mafia that is running. With the result, I can catch cases like this. This is the problem with this jurisdiction. Now, in that context, when you come back to MC settled what Supreme Court said, you are not there. Then 87, the driver was running without a license. The insurance company took the defense. He has no license. Admittedly, provenly, he admitted, and he even pleaded guilty and paid a fine, all that. Therefore, there is no need for further proof. Now, what the Supreme Court found was the driver was not the person who was actually appointed by the owner to be the representative, be the driver on the long trip that the lorry was taking. The actual driver to whom the vehicle was entrusted had a valid and a duly licensed person. He, in the course of traveling, chose to give it to a cleaner who did not have a license. So when the cleaner was at the wheel, the accident occurred. So how the Supreme Court interpreted that particular provision and said was breach of insured. Section 149(2) is talking about the vehicle not being entrusted to a duly licensed. Supreme Court said the breach, the expression breach should be by the insured. This is a case where the insured is staying in Chennai. He has given the vehicle to somebody who is driving and somewhere in Ahmedabad. If he, in the course of journey, without the consent, without the concurrence, approval of the owner, happens to give to a cleaner who did not have a license, you cannot trace that breach to the insured. Therefore, the breach is not a breach by the insured. Therefore, the insurance company is liable to indemnify. In expanding that, they again devoted 2 full paragraphs by saying the purpose of this compulsory motor insurance is not for the purpose of passing a decree full of money, which will remain a paper decree, but it had to fructify and become money which can be realizable and used to the family of the victims. Therefore, law and parliament have made it a very clear mandate that the court should lean in favor of the victim and not in favor of the insurer. Because whenever I went and addressed the insurance companies, which was a lot of times previously, in the last 1 year, I've totally refrained from doing that because most of the insurance companies are, they are all manned by people with only professional, commercial, economic initiative. They have no service motive in their mind at all. They don't like the kind of lawyers that I am. That I will try to, they settle the claim to the lowest possible level so that they can make the difference between what the award will be. And the claimant's counsel, who is in urgency of cash flow, is ready to sacrifice the interest of the victim and settle the claims. This is the tragedy that is going on. Now, when I go to address the insurance companies, the grievance and the grouse they have most of the time is all the courts is totally against us. No court is in our favor. They try to mutilate the law. They try to completely take the wind out of the law, and by somehow making the insurance company, to an extent, that is also correct. It is not as if the courts are completely without any, you can say that they are functioning in a in a manner that actually law mandates them to do. They do tweak the law, but they are expected to do that. For that, I always tell them, you go back to the judgment, again which Soli Sorabji argued, Motor Owners Association versus Jadavji and Modi. That is 1981 ACJ 507, if I remember right. In that case, there was an accident and 5 people were injured. Now, when 5 claims came, under the erstwhile 39 Act 1995-2, subclass A, that there was a limit of liability relatable to the vehicle, nature of the vehicle that was in use. So in that case, the limit of liability of the insurance company was 5,000. It not only said any one accident, it also used the expression at the end in all. It began by saying in any one accident. It also said 5,000 in all. And Soli Sorabji put these two together and said, in every single accident, my liability in all cannot exceed 5,000 rupees. No matter there are 5 people or 10 people or 20 people injured. And therefore, all the awards may have to be shared between the people. You fix their awards. In proportion to what the awards you fix, you pay them out of this 5,000 unless they have taken a paid additional premium. Owner has paid additional premium and covered for an unlimited liability. Now, Supreme Court resolved this problem beautifully by using the expression which all of us know in interpretation of
not
statute.
Audible. Vijayaraghavan is not.
Sir?
No, not audible. I think that some problem.
I don't know. Can you hear me now?
No, yeah.
I think I may have moved away a little from the chair in my... Okay. Now in Jadavji, what the Supreme Court did was they resolved this problem by interpreting it, by ironing out the creases in the statute, which Lord Denning had used beautifully in some of his judgments and which Diplock had commented and sent back the matters from House of Lords to Master of Rolls. In fact, Denning had gone to House of Lords and said, this is not the place where I belong, and came off because he found himself completely claustrophobic. Now, if you listen to some of the lectures, I would recommend Lady Hale. She was a former Supreme Court judge of the first time the UKSC was formed. She became a judge and she has given some brilliant lectures about, and there is one YouTube lecture, a YouTube debate between her, Lady Hale, and the recently dead Supreme Court Justice Ginsburg. You please, Ruth Bader Ginsburg, you must read it. Anybody who has a sense of law, who has a proposition, who thinks about women and having their rights, must listen to that lecture. Brilliant lecture. Coming back to this ironing out the creases in the statute, what the Supreme Court said, there was only one accident. There was maybe one accident, but 5 people were dead. If each one of them accosted his friend or relative or anybody, he will say, I met with an accident, which means each one of them met with an accident. We will iron out the creases in the statute by saying any one accident to mean accident to anyone. This is how, see, this kind of interpretation of the statute to do benefit to the claimant is perfectly within the right of the court and perfectly justified. Or you take the case. Previously, there was insurance policy is now taken. Now, under the previous dispensation, before the amendment was brought under 88 Act, the forms were altered. There was a form of certificate which had to be issued under the 39 Act. In that form of act, only the date of the policy or commencement of insurance could be mentioned and the name of the owner of the vehicle number can be mentioned. No question of mentioning the time. This matter came before the Supreme Court, Madras High Court, Justice V. Ramasamy and Senguttuvelan, Justice Ramasamy and Senguttuvelan, in which the question arose, my senior had argued this case, if I remember right. In that case, the issue was, the accident was shown to have occurred after the policy was taken. After the policy was, before the policy was taken, the accident had occurred. It was very clear, the evidence clearly disclosed. The accident takes place sometime in the evening of one day. Next day morning, 11 o'clock, the policy of insurance is taken, covering from the earlier date, but without mentioning the time of commencement. Now, when this matter went to the bench, Justice V. Ramasamy, the famous V. Ramasamy, who is still alive with us. I won't talk about that any more than saying he was in the Supreme Court, faced all kinds of problems. Now, what happened? He said he wrote this in his judgment. He said, one should not let one's mind boggle that the insurance policy may have been taken prior to the occurrence of, subsequent to the occurrence of the accident, and that the policy of insurance may have been taken by the owner to cover an accident which had taken place earlier to avoid being mulcted of liability by the victims. Now, that is so far as the owner of the vehicle is concerned. Insofar as the victim is concerned, the benefit of compulsory motor insurance is given so that he or she may get the certainty of just compensation. The only way we can resolve this tangle is by not letting our mind boggle, but going into General Clause Act 1894 and go by the definition of day, which says it shall commence from midnight. If day is commencing from midnight, then the insurance policy shall also be deemed to have commenced from the midnight on the day on which the policy is supposed to have commenced, which means the accident would be covering the accident which took place subsequently, and therefore the upheld. This law was upheld even by the Supreme Court. Only subsequently the act has been amended, where the time of insurance policy is now mentioned. And Supreme Court in 1987, ACJ 561, and I remember that judgment, where they very clearly say, now the time is mentioned, it is a special contract, and therefore the insurance companies cannot be held liable. But the problem with the courts is, let us assume there is a case of no insurance policy at all. Let us assume that there is no insurance policy. And the insurance company has been impleaded by not even giving the number, by not even giving the date, by simply saying the insurance coverage is with this company. Now, what sort of evidence will any insurance company be able to adduce? They can't give a negative evidence saying it is not covered with us unless somebody says it is insured with you under such and such policy for such and such period covering the date of accident. The question of insurance company adducing contra evidence does not arise. But what is happening before the tribunals is the insurance company witness will get into the witness box. The insurance company, the claimant will ask him, are you sure how many branches do you have? They'll say we have about 500 branches all over India. Insurance for any vehicle in Chennai can be taken anywhere in Digboy, Assam, or Jaipur in Rajasthan. Yes. Can you say that no policy of insurance has been taken anywhere in India for this vehicle? Obviously, yes. Say I can't say that. He could not have, because he will be lying if he said, I have verified. Obviously, he will say, yes, it's possible. Is there a guarantee that there was no such policy from what you are saying? I can't say. I can only say the policy was not issued in Chennai, in my branch, where the summons were served. We assume they are alleging that policy is issued by us, and therefore we are giving evidence. The tribunal will conclude the fact that the witness has considered insurance could be taken anywhere in India, and he was not in a position to reveal that it was not so taken. We are drawing adverse inference and holding the insurance company liable for the claim. Would it be correct? It obviously will not be correct. It will go against all principles of law. This is on the basis of the principle of this is compulsory motor insurance. Anything goes in this jurisdiction. Now, one other fact. See, I will go to one other fact which is very, very important. Because of this, what has happened is this has become such an easy jurisdiction that fake and false and fabricated motor accidents claims have come by huge numbers. And I think even Kerala is not immune to this disease. See, I saw one letter which I have presented before the Supreme Court recently. Bar Council of Kerala has written a letter to Chief Justice, who is now the Chief Justice Manikumar, is from our court. They've written a letter saying that this is the jurisdiction we are practicing. Don't try to put too many hurdles in our practice. This is where we survive. You please consider, while considering about the interest of the victims, please consider about the interest of the advocates also. Strange, absolutely strange. By reason of this only, the principle of champerty is prohibited all over the world, except in Singapore and USA. There is no contingency fees that is payable. But it is a matter of fact that contingency, there is a judgment of Supreme Court in state of Telangana versus Sakuntala, where Supreme Court has recognized this. Somebody gave a check for a fee, it bounced, and a suit was filed with the advocate. It went to the Supreme Court. Supreme Court said, it is obvious the contingency fee is being charged. We don't agree for this proposition. Now, how these fabricated claims, Tamil Nadu is a precursor, Madras High Court, we have done pioneering work in that. It started way back in 1990, 2003. It started in 2003. Now it has come to SIT being appointed recently also by Justice N. Anand Venkatesh. Now, how it all began was this. You all know motor vehicles are sold in melas. Now, there was a mela that was happening in Trichy. When the mela was taking place, there were several vehicles which were purchased by one advocate. One advocate, he purchased several vehicles and never transferred the registration certificate in any other name. He kept them all in his garage. And what he did was, he used to renew the policies every year. See, under the Indian Motor Tariff, GR 32, General Regulations 32, talk about registration certificate being necessary for insurance. But if it is a renewal, no insurer asks for the registration certificate. The policies, the vehicles which are bought had already insurance. So this man continued to insure in the name. So whenever an accident occurred or no accident occurred, somebody died due to jaundice or fell from a tree and he thought of filing a claim for a motor accident, he used to implicate this vehicle. Police also contributed by registering the FIR with the result. Now what happened? While filing two claims, he used the same vehicle on the same day, 200 kilometers apart. It was discovered or found out by us only by chance. It could have easily, because it was two different insurance companies, we would not have been able to do it. It happened to be National Insurance, same branch, and this gentleman, while being a crook, was not clever enough to avoid this possibility. So we discovered that, and we went to court and pointed out that there is fabrication. Though then, when we went to the High Court Justice R. Balasubramaniam, he escalated the matter instead of police to CBCID to investigate. And we found that CBCID was no better than the police, because one commissioner of police who came to my office personally and met me, he said, why are you trying to, raise the tail of a dog? It's impossible. There is so much of money in this jurisdiction. In no way any policeman is going to avoid making money. No advocate is going to avoid making money. If you don't want to make money, take part in you be outside the jurisdiction. Don't try to come and clean this jurisdiction, which is an impossible task. No way you can do that. But what we did was, we compiled a case of 1,081 cases, 1,081 claims, which were all fabricated. We went to the High Court and said CBI should step in. Chief Justice A.P. Shah and Justice Prabhasi Devan, it's a reported judgment, National Insurance Company versus Directors CBI. 1,081 cases were reported. The report happened on 1/3/2006, the Supreme Court, the judgment of the Madras High Court. I remember 1/3/2006 very significantly because, and it was also a Wednesday. Why I remember that? Because the very next day, 2/3/2006, Thursday, Chief Justice Shah called me and Justice Kannan and asked, why don't you become a judge? I refused. So you are suffering the consequences of the lawyer coming. Otherwise, I would have been somewhere. So I refused to become one. And another date I remember was 5/8/2011 when Justice M.Y. Iqbal also called, and both of them I declined for the reason I don't belong there. For all the things I am urging, I would have been a complete misfit on the bench. So that I am very sure of. Now, what happened after CBI came on the scene? Please note this particular fact. And the way Supreme Court approached it also, I will describe. 180 crores worth claims were withdrawn. The moment CBI came on the scene, Mr. Gopal Subramaniam, senior advocate, came to Madras and he said 1,081 cases is too much. We are in no position to handle it. It was also the time at which 2G was also coming. 2G or some other big scam was also there at that time. He said we cannot devote so many personnel. And it is always a fact that the government always keeps CBI with the lowest number of personnel because they can control and dictate all the terms. They never give CBI the entire infrastructure they require. So that is a matter of fact. This is what Chief Justice A.P. Shah told me and said, don't insist on all 1,081 cases going. Only 23 cases we will do it. Okay, we agreed. We sat, selected and referred. The moment we started, but he made it very clear that 23 will not be final. There will be more because I told the court, unless you keep the options open, the impact on the ground will not be there. Within 3 days, in one court, Rasipuram, in one court, 90 cases filed by one advocate was withdrawn. 90 cases filed by one advocate. We could not take him to task or go against him because the purpose which we were setting out to achieve had been achieved by the withdrawal. Now, after this withdrawal of 180 crores, there was one claim which was pending, which we did not refer to CBI, but it was also a clear-cut fabricated. It was a murder which was converted into an accident, and a claim was made. The evidence was crystal clear, except that the insurance company was not in a position to establish as required in a court of law. Because you see, the procedure under 169 Motor Vehicles Act may be summary, but the courts construe the summary nature of evidence only for the claimants, not for the respondents. The respondents are required still to establish as in Evidence Act. This is the law that is applied throughout India insofar, but that is also correct. I am not complaining. I have no grievance against it. That is because it is in consonance with the compulsory motor insurance principles. But now in that murder case, what the learned judge of the tribunal did was, I remember she also came to the High Court, she was also, then what happened? She wrote, I am satisfied this is a false and a fabricated claim, but for humanitarian conditions, I am not in a position to agree to dismiss the claim. Accordingly, I am directing the insurance company to pay so much of money towards the medical expenses the person has incurred, which will be more as a gesture of goodwill from the insurer, not as a direction. But it was a huge sum of money, 20 or 25 lakhs. So I took the matter. It went to the High Court. High Court also confirmed it, because when I went to the High Court, the single judge said, what are we going to? It's only such a small sum of money. Why do you want to haggle over it? You are succeeding in so many other 180 crores. So I went to Supreme Court. The Supreme Court judge before whom I argued was Vipin Nair knows about it. Vipin Nair and P.B. Suresh only moved it. G.S. Singhvi was the judge. You know what he asked? How much money have you saved from the CBI reference? 180 crores. What is the amount involved in this case? 25 lakhs. Piffle, dismissed. Simple. This is the approach that the Supreme Court adopted with regard to false and fabricated claims in those days. Now at least there has been a transformational change. And on 5/1/2017, if I remember right, Supreme Court has in ICICI case ordered notice to all the state governments. Now, one of the important features coming back to the technology aspect is the detailed accident report regime that Justice J.R. Midha. Anybody who wants to know anything about motor insurance should read his judgment. He has published a small Delhi Judicial Academy book. He gave it to me as a gift when I attended along with him as a resource person in National Judicial Academy. In that, he has compiled all the judgments. Incidentally, I would like to say, he is one of the few judges who has taken or made full use of Section 165 of Evidence Act. I don't know, the judges here, may recognize that provision. That is a provision even the appellate court can call the witnesses and find out what the evidence or truth should be in a given manner in the High Court, even when the proceedings are on. And then they can add on the evidence and decide the case accordingly. He is one man who has made he has made innovations in that 165 Evidence Act. That J.R. Midha, in the course of evolving this, under the Motor Vehicles Act, Section 158, subclass 6, it is the recognition of public interest litigation. Actually, you go back to Bhagavati's Bandhuva Morcha case and so on. A small postcard can be treated as a writ petition and all. Parliament for the first time recognized that an FIR can be treated as a claim petition. This is fantastic. A judiciary delivering a judgment and the executive and legislature giving recognition to that particular innovation of public interest litigation in a statute. Wonderful development that has been made in this regard. But unfortunately, the accident information report as per Section 158, subclass 6 of Motor Vehicles Act 1988 was very small. Only few facts were available. So what Justice J.R. Midha did was he has expanded on that and converted it into a detailed accident report regime, DAR regime, and then came up with a complete solution. Now, we picked up what Supreme Court did was on 13/5/2016, Justice Khalifullah, the day of his retirement, because he is also such a good friend. I meet him all the time in the Marina Beach. Wonderful. The man who also wrote the judgment in Sri.N case, where with regard to releasing the releasing Rajiv killers, one of the finest judgments. He told me the 1087 pages of judgment he wrote by hand. He wanted it to be confidential. He did not even believe his stenographer or anybody. He wrote in hand and then dictated over a 7 days period without letting the stenographer go home. Wonderful judges we have had all along. This Khalifullah judge in the Supreme Court in Jayaprakash versus National 13/5/2016 picked up the Dar regime, and instead of each state having a separate rule, separate provision, separate regulation, he said, no, apply it pan-India. We make it a mandate of Article 141 of the Constitution. It will become the constitutional law of the land, and therefore, what we did was Justice P.N. Prakash of Madras High Court, I brought it to his judgment. Within 1 or 2 weeks of that, we had some litigation where I brought it to that in Cholamandalam versus Inspector General of Police, Criminal OP 18110 2016, if I remember right. What we did was, we went to the police and told them, you are now compelled by Justice Nagappan's judgment to upload all the FIRs as a matter of rule, no matter what the offences are, except sexual offences or murder or sensitive ones which are excluded by the category in the judgment of the Supreme Court. Now, by reason of this, why don't you develop a digital platform by reason of which we will be able to upload not only the FIR, all the documents and make it available to the claimants by virtue of mobile or access to the internet, and avoid the need for sale and purchase of victims in police stations and elsewhere. Now, the State Crime Records Bureau on the CCTNS platform, along with National Informatics Center Pune, was developing a platform, and they appropriated it, and we repeatedly gave directions. It was not an adversarial proceeding at all. It was a wonderful proceeding where everybody got together, put their heads together, and came up with a lovely solution, which is working like divine in so far as Tamil Nadu is concerned since 1/3/2017. There are lakhs of documents have been uploaded, and each document is available to the claimant on a payment of ₹20, and for the insurance companies on a payment of ₹200. That is all. And the downloaded documents have got a watermark. With the result, Section 65B Evidence Act very clearly says, if it is allied with the IT Act 2000, it can be marked without any oral evidence. Now, the whole process has been short-circuited. Now, thankfully, what has happened is, Vipin and I are forming a part of an amicus team in WP number 534 of 2020, which is now ongoing litigation before Justice Sanjay Kishan Kaul and Subhash Reddy, which is now slated to come up on 4/5/2021, in which they have given a slew of directions A to H by appropriating what Justice Prakash has said to an all-India platform. And now Bajaj Alliance has been asked to, is developing a mobile app by reason of which everybody will have complete access. Now, the one limb that is missing in that is once the compensation is deposited by way of a NEFT transfer into the bank, whether the claimants are able to lay their hands on it. That is the tragic story that still yet to be solved. That story, if it is to be solved, I think Kerala has got a huge objection. The advocates in Kerala are really raising the bar too much, and they have even struck work in so many cases, and they are refusing to come to Lok Adalat and settle because the entire practice will come to a standstill. It is a matter of common knowledge that they make huge amounts. See, I had a friend. I don't mind disclosing his name also because he is dead now. M. Swamikandan. He was a wonderful friend on the claimant side. I'll give you 2 anecdotes from after which I think I'm holding all of you much longer than what you had intended to. I think I don't mind going beyond and explaining whatever I'm coming to my mind. I'll give you this fabulous anecdotes involving this M. Swamikandan. He was a great friend of mine. Within 2 years, he started his practice before a retired judge, Abdul Wahab, who was practicing Supreme Court or somewhere, and then he was practicing before him. Not much was going. So he decided he had very difficult financial condition. He had to make money. His father had a small extent of land. So he decided, people advised him, sell that land, invest the money in motor accident claim, make a huge profit. You can be a great advocate. So he decided to do that. and he came. See, one thing about this gentleman was he was a rustic villager. He used to claim 10 lakhs for claims which are worth 1 lakh. But he will not file a false or a fabricated claim. He will not invent or make up stories or tamper with documents. He was not given to all that. But claims worth 1 lakh, he will claim 10 lakh. Claims, because those days we had to pay 1% court fee in Madras. Not many people were willing to pay. This fellow was willing to finance, and he used to pay a lot more money to the police to get all the cases. Now, within 2 or 3 years of his practice, he bought a Benz car, 46 lakhs of rupees. When I was coming out of my office, I saw this fellow standing in front of the gleaming car. I asked him, whose car is this? He said, I've just bought it. And then he told me, how did you buy it? This is what he said. Then I said, most of the money for purchase of this car is contributed by me as being a respondent. So you owe it to me to take me to my house and allow all the people in my house to have a ride in that vehicle. So he came home. We went around. My sister-in-law also drove it. And my driver also at that time had a ride. And they all enjoyed it. They were all happy. While coming back, what happened? A small cyclist, a young boy who was coming next to that, he crashed against a car, and there was a huge scratch on the right-hand side of the Benz car. 46 lakh was. When he came and he knew about it, he never bothered about it. You know what he told me? That I never complain about the scratch because the Benz car is only 1 day old. And such a scratch, if I go back, he will charge 15 lakhs, 20 lakhs for setting it right. That is how the dealers charge. But I am very happy that the car got scratched like this, because he said, when my father was, when I was very young, and in my village, some big businessman and agriculturist who had lots of money bought a big car. He came with a new car, a gleaming car, and the whole village assembled and all that. And my father, unfortunately, coming from the field, he hit that car and scratched it. And there was a huge hullabaloo about it. And my father was put in the dock, and he had to pay money. And he could not pay money. He had to borrow money, and he had to pay and all that. So all that was reminded. If my father had not done that, probably I would not have come here. And this is the kind of wonderfully emotionally involved fellow. Now I'll give you 2 illustrations as to how I am willing to accept such candidates in the motor accident field, but not others. I will give you one instance. It was a claim before a court, before the small causes court. We negotiated, the award would have come to around some 2.75 lakhs. We agreed, and we both agreed with the learned judge. And we told him, please write down this number. You pass an award as if on merits for this amount. And the agreed amount, if I remember right, was 2,75,000. Both of us went off. This was on a Thursday. On Friday evening, he calls me. He says that 2.75 lakhs we may have agreed, but the judge is going to pass an award for 3.25 lakhs because he has asked me to come under the subway next to Ega Theatre and pass him some compensation for awarding compensation to my client. So he told me this, but he told me, I will still stick by our agreement of 2.75. I will pay out of whatever compensation I pay to the judge. I will pay out of my pocket, or my share it out of my fee. Now we both come to the court on Monday morning. The award is for 3.25 lakhs. You know what happened? The judge calls both of us and he says, I was just computing the calculation. I found that 2.75 was too low. When I calculated, it came to 3.25. Vijayaraghavan, I'm so sorry that I had increased the award from what you had agreed, because generally you give us a lot of disposal. The MACTs had to dispose of 56 cases per month. And I used to give about 30 or 40 disposal for each judge. By my ability to come to a understanding with the judge, with the advocates on the other side, never contested against me. Because our office was completely fair, and we will tell where we had to win, they will concede. Now, in that case, the judge said, Vijayaraghavan, I'm so sorry, I have escalated the award to 3.25. But in order to compensate, the next claim of so-and-so, I have dismissed it. Now, please tell me what sort of poetic justice is this kind. Now, in that case, what Samikande did was, the dismissed case was only about 50,000 rupees. He paid out of his pocket for that claimant also and settled the claim. I know it because he did it in court in my presence. And the other instance I will give you what happened in the High Court. Now that came before, if I remember right, Justice A.S. Venkatachalamurthy is no more, I think, I don't know, and Jnana Prakasam. This was an award for an engineering college student for some 5 lakhs or 6 lakhs or whatever. We filed an appeal saying it is too much because we found out that the college student had not suffered so much injuries and all that. And when we went to the court, so Swami Kanna asked the client to come to the court. The judges said, we don't have time. We deal with the case in the chamber. You please come upstairs. So we went to the upstairs and the fellow came by lift. He was having crutches and he was standing next and his old mother was also standing next to him. And the mother said, I brought this fellow up by selling idlis and dosas on the platform. Now I was about to make him an engineering college student and on the verge of it, he has suffered a serious injury. And therefore, our whole life has come to a standstill. It has become dark and our future itself depends upon what just compensation this court can award. I did not open my mouth. These were all true. The judges were accepting everything was true. And they escalated the award by 5 times or 6 times, if I remember right, 20 or 25 lakhs. And they said, we will pass a final award day after tomorrow. And then you please come, both of you. We will pass and produce and pronounce the award and hand over the copies also to you so that you can ask the insurance company to satisfy. So we were both coming to the office, my junior and myself, we were walking up the stairs. When we were walking up the stairs, somebody ran ahead of us across to the chamber of the court. My junior immediately pointed out, you know who is the fellow who is running to the court, running to the chamber of the judge? It is the victim who is running to the chamber of the court. He will run to the chamber, pick up the crutches from outside and go inside the chamber with the crutches. He is nowhere near what he is disabled, he claims to be. One. The second thing is, during the 2 days' time, I had made some inquiries, investigation and found out this fellow has already been employed by Infosys and in Alvarpet he was being, what we did was, we made a phone call to the Info, we came to know he was in Infosys. We said, we are looking for a bride for this boy. Is it true he is earning? They said yes. We asked them to send a fax copy of it. They sent a fax copy of the salary, everything we had. Now, when the judges were about to pronounce the award, we had this evidence, but I did not openly disclose it at all. I just kept quiet, let the award come. I waited for the award to come so that I can file a review petition and expose to the judges what is the mistake that they are doing by assuming that everything that is being represented to them is true. They are not applying their mind or assuming that this jurisdiction is full of people who are trying to make money out of a misfortune. Now, when this matter came up, subsequently, when I went and accosted Swami Kanna and gave him all the papers, within 2 days, he gave a letter not pressing the award that has been passed in the appeal. And he paid the entire compensation that he had to pay to the claimant. Now, you can ask me one question. If you had not got this evidence and accosted Swami Kanna, he may not have agreed to withdraw. Possible. But I would not say he's a perfect gentleman, but he's a gentleman among crooks. That is what I am not looking for now. Crooks, more crooks, higher crooks, that is all is available. When I used to tell him about that, Swami Kanna as ambulance chaser, he used to tell me, I may be an ambulance chaser, I am not disputing it. You are also now an insurance company chaser or a transport corporation chaser. That is also the reality that has come about now. That is also a tragic reality that, because whenever I went to argued before the Judicial Academy talking about fake and fraudulent cases, I remember one real fight I had in the presence of Madhavan, Bangalore, N.R. Madhavan. In his presence, I had a real fight with Chief Justice of Jammu and Kashmir, Paul Vasant Kumar would come there. I remember we had a real fight. He said, you are no better crook than or no lesser crook than any of the claimants. At least those people are victims. You are trying to make you are trying to survey on the basis of victims. You are only a you are only a parasite. So on and so forth. But the tragedy is this: that jurisdiction is so full of money, so full of moolah, that nobody talks about the law or the insurance or any other aspects of crime. Now, what I am looking for is a scheme. You all may be aware of the M.R. Krishnamurthy judgment, which has come on 5/3/2019 of Justice A.K. Sikri and Ashok Bhushan. It came on 5/3/2019. It is in the case of an M.R. Krishnamurthy, who is an advocate and whose case was argued by Mr. Arun Mohan. Now, subsequent to that, the Supreme Court has appointed a committee of the Registrar Fansare, in which they wanted implementation of M.R. Krishnamurthy. Unfortunately, in the Madras High Court, the Law Association, instead of the claimants, Law Association has challenged the order that Justice Prakash has passed for against the provision of annuity being the basis for giving compensation. If annuity is going to be the basis for compensation, no advocate worth his salt practicing in this line will be able to make millions or buy the Mercedes Benzes that Sami Kanu was enjoying. Vipin Nair and P.B. Suresh are now handling this SLP. Now, what we are trying to do is, see, one important development I need to point out in the context of Kerala. In the context of Kerala, there is one development which is now pending before a 3-judge bench of Justice N.V. Ramana. After he becomes a Chief Justice, possibly it will be taken up, where I have been appointed as an amicus. This issue relates to awarding costs in MACT claims. The principle that the Kerala High Court seems to have taken is costs are awardable, and that one the insurance company has challenged it by saying costs are not available because the Kerala Motor Accidents Claims Tribunal rules do not include Section 35 CPC as part and parcel of the rules. Now, this matter has been escalated while dismissing the appeal filed by ICICI. The 3-judges bench has framed a simple question whether costs which are payable in constitutional cases and in civil jurisprudence applicable to MACT claims. It is so simple. Justice Krishna here has written so many judgments. I remember one direct judgment after in 1979 ACJ 205 in the context of Order 33 Informa Pauperis. He said, if any principle is available in CPC, whether the provision is applicable or not, it can be invoked and it is applicable. And in the context of negligence also, he wrote, road accidents are major killers in the country. Courts should not succumb to niceties, technicalities and mystic maybes and allow culpable drivers escape responsibility by being swayed by a doubt here and an obscurity there. Mere preponderance of probabilities will apply. Closure of a case for acquittal or a discharge or a mistake of fact is irrelevant before a claims tribunal because a criminal court requires beyond reasonable doubt as a basis for evidence. After all this, for a Kerala-based insurance company or an insurance company from a Kerala claim to come and argue that costs are not payable is a ridiculous argument. In fact, we could not tell before the Supreme Court, the question posed by you is irrelevant because there is not 1, 2 or 10 or 20 judgments, but 208 judgments all over India which say costs are applicable in motor accidents claim, no matter that 35 CPC is applicable. This is on the simple logic that a claims tribunal, be it a persona designata or a tribunal by its own formation, is having the trappings of all the trappings of a civil court. This is settled law. Absolutely settled law. Why this is a big issue in Kerala is for the simple reason. Costs are being awarded for advocate fees also. And that advocate fee alone is being paid to the advocate. And rest of the claim is being directly given to the claimant. And the advocate community is not comfortable with that. Now the insurance companies are saying, what is the cost that is to be levied? What I have seen in the Madras High Court, the similar thing happened, where I proposed to the Madras High Court, instead of looking for how to see Arbitration Act has got a procedure for levying fees for the arbitrator, or the advocates can choose the legal practitioner's fee rules and so on. But pan-India, what is available? Pan-India, what is available is legal services authorities are available in every state, and National Legal Service Authority is available at Delhi. They have a panel of advocates who handle MACT claims also. Why not have the structure of fees they are paying to those advocates who are pursuing claims for claimants on legal aid basis? That can be Madras, Tamil Nadu has applied it. Now we are recommending that to be applied. See, in this context, I need to point out a couple of instances because I've always been the kind of lawyer that is, because I can't sit quiet in nowadays. I don't go inside a court when a proceeding is going on. I do. Now the hybrid version is very difficult for me because I have to hear a lot of arguments which are going completely against the logic or law that I consider is correct. So I find it very difficult. I agree. Now in Madras High Court, I will not go into any chamber. Previous those days when I was young, I used to go. One day I was sitting in a court of Justice Satyadev and Justice Padmini Jasdure. She was the first woman judge of the Madras High Court after about 100 and so many years. Padmini Jasdure, she was a public prosecutor. She was sitting in the court and a senior advocate was arguing for the insurance company. The argument was this: the license for the driver of the vehicle was only a learner's license. Therefore, the insurance company is not liable for the claim. Now, this was the argument advanced by the insurance company. He was also relying upon a few decisions which have been given by the Madras High Court itself in that context. So, he was arguing on that basis. Now, when I was sitting in the court, I was just listening. I had nothing to do with that case. I'm not supposed to get up and say anything like that. But I was very exuberant, irrationally, possibly, at those days. So, I got up and told the judges what the learned advocate seems to be arguing is maybe contrary to the instructions his own insurance company, his own client has given. Now, he turned around and asked me, do you have the substantive basis for whatever you are saying? Without hesitating, without telling them I did have, I just ran out of the court to my office, which is in the opposite building, pulled out a circular which I have collected and gave her. Now, that circular has got a parenthesis in which it clearly says, other than a learner's license. What the law very clearly said is, those days, now the law has slightly changed, 39 Act, Section 3 and other provisions have slightly changed. Even the clause in the insurance policy. Those days, the clause was, if a person had a permanent driving license and it expires, then subsequently, if he does not have a license, if he drives with an expired license, he will still be liable. Now, in the context of the learner's license, what the policy said was, the learner's license that the person is using on the date of accident should be valid. It is sufficient if it is valid, but it should not have been expired. That is the distinction that they were drawing in the clause, which I brought out by way of a circular. Now, when that circular was brought to the court, brought to the notice of the court, they really slammed that advocate and the insurance company. And ever since I have learned my lesson not to do this, to expose the advocates like that. Because I'll give you a couple of instances where I was tempted to argue the way I see in an accident claim. I was arguing before Justice M.N. Chandurkar, Chief Justice M.N. Chandurkar and Justice M. Srinivasan. There was one sheet of paper which I had to explain to them to communicate the ground I had. That was in Tamil. Now, Chandurkar, being from Nagpur, did not know, was not comfortable. So he said, young man, why don't you, I was young once, not now maybe, but I was young then 30 years ago. Now he said, why don't you translate and bring it? I was not a person, I am never keen for any adjournment. Any case which can be argued today, I would like to argue yesterday. That is my style of submissions. Now, when I told the judges, no, don't. Instead of producing a translated version, now the Tamil version your lordship is having, I will read the Tamil in English. Justice M. Srinivasan, who is familiar with Tamil, let him translate whether I am authentic or my translation has the integrity to go with the vernacular version. So Chief Justice said, yes, go ahead. So I read that about 15 or 16 lines in English straight. The learned judges were so impressed, they said they're going to allow the appeal. Then I turned around and said, this is not a fit case for appeal. Please modify the order like this. Ever since in that court, my senior never went to that court. He always used to send me because Chandurkar, whenever I got up, he used to admit and then tell me, what is the case, please tell me. See, that is the reputation you need to make in a court of law. He, despite being in the MACT line, was able, but times have changed. Very recently, before another judge who had come from outside court, I tried this trick. I told him I'll read in English. Do you mean to say that you won't translate, you won't follow the directions of the court? You may be a talented person and read Tamil in English or Telugu in Urdu. We are not bothered about all this. Follow the practice. See, what happened is after that, the relationship got ruptured. Times have completely, I'll give you one more illustration with that close. Why you should, whenever you read a provision, V.K. Chari, who is a neighbor of mine, V.K. Tirvengadachari, Advocate General, he was a man who was instrumental for 9th schedule in the Constitution. And the first amendment after the Champakam Durarajan case, 1950-51, 9th schedule, where you put the statutes which will be beyond the scope of judicial judicial review and so on. He was the man who suggested to Justice K. Kamaraj, and he in turn did it to Nehru, and Nehru put it there. Now, of course, whether 9th schedule is surviving or not is a matter of concern. It has gone to the Constitution bench. Now, I was arguing a rent control provision because I need to impress on you with some other cases also, because you don't go away with the impression I'm an MSCT lawyer. I am no longer an MSCT lawyer. I made it because that is why I am now refraining from making any such lectures on motoring. I have refused 101 requests from the insurers during this period for such similar webinars. I obliged only because the gentleman judge asked me, and I found Mr. Shyam to be an enthusiastic gentleman who is now close to double century now. That is why I was doing this rent control case with regard to demolition and reconstruction. And the man who was opposed to me was one Mr. M.R. Narayanaswamy, a Jambavan senior advocate of those days. He was one of the finest advocates the Madras High Court had seen, very highly respected and wonderful gentleman. I'll give you 2 illustrations, not one, because you need to know both. Because I'll make it interesting at least when I'm concluding. Now, in that case, rent control matter, demolition and reconstruction, section 14, it was at the CRP stage under section 25 of the Rent Control Act, 3rd round of litigation. The ground raised by the tenant was that the landlord had failed to give an undertaking in the rent control petition that he will demolish the premises and reconstruct and put him back in possession within 4 months. There is a requirement of such an undertaking in the statute, failure of which the petition will be held to be not maintainable. And it was coming up before Acting Chief Justice S. Mohan, who went to become Supreme Court judge also. He had a liking for me because we both had a literary, because he wrote the foreword for my first of the books, and therefore we became very great friends. And he was wonderful in not only the vernacular and the English, a few other languages also. So when Mr. Narayanaswamy pointed this out, and he also submitted a judgment of Justice T. Ramprasad Rao, who was the senior of Mohan, Justice Mohan. So I thought my goose was completely cooked. I'm going to lose this case, despite succeeding in 2 rounds, and 3rd round, it may have to go back and start all over again with an undertaking in the petition. Then what V.K. Thiruvengadachari told me came to my mind. What he told me was, a good lawyer is not one who knows good law, but one who knows where good law is. So he always used to tell me, whenever you deal with a case, don't look at the facts alone. And when a provision comes for application, read the provision even if it is for the millionth time, in the context of the case you are dealing with. He said so even in the context of section 151 CPC. So what I did was I took that section 14, I told Justice Mohan, let me have the benefit of that, and I started reading it. When I read it, the moment I read it, something struck my mind. Then I told him, may I read it aloud, my lord? So I read it. No court can grant execution in a petition without the benefit of undertaking being given in the claim petition that is filed by the landlord seeking eviction of a tenant. This is how the provision started. No court shall. So what I told him was, you are trying to tell me that without the undertaking, my petition is bad because it is a condition precedent. Now I am turning the table, flipping the facts and pointing out to you, no court shall. It is an embargo placed on the court from granting a decree to me, not a requirement for me to give the undertaking. He read it again. He read it again. Then he told me, how do you intend to solve the problem of the undertaking? I said, I will give you an undertaking within half an hour. Then you can give me the decree. Or you can say the decree of the trial court is affirmed, confirmed by the 2 courts being concurrent judgments with liberty to the tenant or with a direction to the tenant to file a petition of undertaking within such and such time, after which only the decree will become applicable for execution. He was really fascinated by that. M.R. Narayanaswamy said, Milord Ramprasad Rao judgment is binding on your lordship. He said it is binding so long as he has I am going to take the same view. I can now point out how that judgment is eminently distinguishable. In such of those cases that judgment has come, if the claimant files an application for review or possibly reopens seeking time to file a undertaking, it will still become alive. It will be resurrected as a decree. And therefore, there is no conflict between the two judgments. I'm not referring to division bench. In the context of M.R. and Sami, I'll conclude with this anecdote. Wonderful anecdote, which I will never forget in my life. Now, I was doing a case before Justice K.S. Bhaktavachalam. He was a wonderful judge, a wonderful, very, very funny person. He used to enjoy. I'll give you one anecdote also in that context. I need to say my Sampath Kumar, when we were urging arguments in a writ petition, our typist had typed for the above said reasons, this honorable court, instead of this honorable court may be pleased to, he has typed as this horrible court may be pleased to. So Justice Bhaktavachalam saw that prayer and he asked Sampath Kumar, Mr. Sampath Kumar, what do you have to say about this? Honorable, horrible, how long have you been thinking of this court in that context? Now Sampath Kumar looked at it and immediately, you know how you should think on your legs. That is the most important thing for any advocate in practice. Now what he did was, that day, the writ petitions were supposed to be posted before another judge. That judge went on leave and therefore the cases were transferred to this zone. So Sampath Kumar said, Milord, the horrible, the adjective is not meant for your lordship. It was meant for the other court. And fortunately, unfortunately, your lordship is sitting and that. He really laughed out loud and gave the order. When I was arguing that particular case, I still remember, it was a case relating to a bank. A service condition was under challenge. If I remember right, it was Syndicate Bank. A service condition was being challenged by a union. So I was arguing the matter on behalf of our office. I was very young at that time. And the person who argued against me was K. Chandru. He went on to become the High Court judge. Justice K. Chandru is now retired, a very, very well-recognized service law-oriented advocate. Now, he was the person who was arguing before me. Now, when I was arguing before Justice K.S. Bhaktavachalam, I tried my level best to succeed. But I could not because the facts and the law were totally against me. I did not concede. I argued as well as I could. Then I went near the judge to the podium and I told him, please don't put my name. N. Vijayaraghavan argued for the bank. Put my senior's name, S. Sampath Kumar argued, because the bank is a public sector institution. They would not appreciate a junior of Sampath Kumar being sent to argue such an important matter which will have pan-India implication. He refused. He said, no, you only argued. He turned around to Chandru and asked, did he miss any point? Chandru said, no, he argued much better than what Sampath Kumar would possibly have done. He was trying to pull my leg and tell the judge it's all right. So what the judge did was, he wrote in the judgment, N. Vijayaraghavan for senior advocate S. Sampath Kumar. He wrote like that and passed the order. It was against the bank and the bank immediately, the bank management took serious notice of it. And they said, why did not Sampath Kumar go and argue this case? Why did he send a junior or a rookie who has argued? We have lost the case and it has all India, pan-India implications. So they were transferring the case to some other advocate. They took up the matter and sent the appeal to another office, T.S. Bhopal and Associates, very famous. He's still living with us, about 91 years, a wonderful service law lawyer. Now, T.S. Gopalan engaged M.R. Narayan-Samy as the senior. And M.R. Narayan-Samy took hold of the papers and saw that Sampath Kumar's office had argued this case. He was wondering why, when Sampath Kumar, such a leading panel advocate of almost all the banks, including Blood Bank, why should they take up the case and give the appeal to some other lawyer who's not even appearing for the banks, but only for other management? So he called Sampath Kumar and asked what happened. Sampath Kumar disclosed what had happened. This is what had happened before Bhaktavachalam. So Sampath Kumar asked me to go to, Narayan-Samy asked me to come to his house. It is the house has been now demolished. Number 1 St. Mary's Road, Arepuram. I will not forget. I went into his house at 6 o'clock. He called me. 6 o'clock. He was sitting in a jula. That is his usual practice. And he was having a cup of coffee. He asked me to sit in a small stool. And he said, I'm going to close my eyes. Please argue the case as if you are arguing the appeal. I argued before him. He said, what's wrong with the order? What's wrong with the order? Where is the ground for appeal? Nothing is there in the ground for appeal. That is what we had, sir, that is what we told the bank. Bank was not listening. They were very angry that I had argued the case instead of Mr. Sampath Kumar. So he told me, tomorrow the matter is coming up before Chief Justice Mohan and S. Ramalingam, two of the finest judges you can have. They were so sharp that you had to argue 2 minutes. They took only half a second to conclude. Before you could open your argument, they will start dictating. That kind of judges, they were absolutely brilliant. So Chief Justice Mohan and Ramalingam were sitting. M.R. and Sami went to the court. He was arguing for the appeal. And M.R. and Sami insisted that 4 of the top officers from Syndicate Bank should come to court and watch the proceedings. So they were sitting. M.R. and Sami asked me to sit in the row behind in the first. I don't know how many of you have seen, they had the benefit of the first court of the Madras High Court. It was absolutely brilliant. We were all disappointed when Chief Justice K.G. Balakrishnan removed all the seats and put chairs and made it like Supreme Court. Now we are back to where we belong. It's about 150 years, a proud heritage. At 3:45 in the evening, you can see light coming from the colored windows. And what a lovely sight it will be to sit and argue in that court. Very inspiring. Now I was sitting in that seat where exactly at 3:45, that light was falling, and that's why I remember all these facts. Now M.R. and Sami got up and argued for admission. Chief Justice Mohan said, we don't have so much of time today. Rana and Sami, since you are appearing in this case, and it is only the first round, we will admit this case and order notice. Stay, we will consider later. We don't have time. I am rushing for some administrative work. Then Narayan Sami said, no, my lord, I have some serious arguments to make. Your lordship should give me at least 5 minutes or 10 minutes. He told. Narayan Sami told him exactly what happened before Justice K.S. Bhaktavachalam and how the matter was transferred to another advocate who had filed the appeal. And I was sitting next. And since I had argued wrongly, the bank, according to the bank, there were 10 Chief Justice Mohan, he called all the bank officials to the front. Who signed this grounds of affidavit? Who signed the wakalat? Who signed the stay? Each of them recognized. Now, please, I want you to argue this case, how K.S. Bhaktavachalam's judgment is wrong. All of them were really sweating. They could not open their mouth. And he asked, what is the mistake you have found in the order of Justice K.S. Bhaktavachalam? I want to know. Otherwise, I am summoning the chairman of the bank to come here and present himself tomorrow itself at 11 o'clock. I want to know. This is an insult to the member of the bar. This is an insult to the great senior advocate Sampath Kumar and his office. They have done a wonderful job. If you go to a barber, do you think always the senior barber will be available to shave or do you a haircut? The juniors, how will they get trained? Have advocates become worse than barbers? He really took them on. He said, let my administrative work remain. Let as much time as be taken. I want to sort out this problem. The bank men really got together and consulted, and they went out, T.S. Gopalan, they went out and said, tomorrow morning you file. No, I am not filing tomorrow morning. Today by 5 o'clock you are filing an affidavit apologizing for what you have done. Then they said, Finance Ministry, no, let the Finance Ministry go to dogs. I don't care a damn. How the Nationalized Bank has insulted an advocate who has done his job, and you are not able to show how the judgment of K.S. Bhaktavachalam is wrong. In fact, if you want, I will ask K.S. Bhaktavachalam himself, who is a junior judge, to come and argue before us how his order is correct. Really, it was fascinating duel between all of them. And ultimately, he asked them to file an affidavit, and he told the bank that they should empanel me in their bank. I refused. I declined. Because I said, as a matter of principle, I will never get into any bank because it is the most bureaucratic establishment which doesn't deserve the service of the kind of people that I am, at least I think I am made of. I think I've held you long enough. I can go on and on for a long time. It will be a torturous thing for all of you. I don't know how much of overview of motor insurance I have covered. I have only covered whatever came to my mind because I had not prepared myself. I'm so sorry, Mr. Shyam Padman, if I have failed your requirement of handling or addressing the particular topic you give to the resource persons. I'm so thankful all of you have stayed together and all of you are stuck. I don't know how many exit options were pressed. Thank you very much.
Thank you, Vijayaraghavan sir. And to be frank, the name of the platform itself, sir, Legal Empowerment Through Interaction Lecture Series. Empowerment can come from different quarters on different ideas, and calling a spade, that too on the face of it, is something wonderful. Ramkumar sir, your take on that.
Thank you, Shyam. We had an excellent articulation. More than law, advocacy, common sense, and whatnot. And you have a remarkable memory regarding dates. Dates, you have a remarkable memory. I was reminded of Mr. V. Ramaswamy, former attorney general. He was not only quick-witted, but he had a ready answer to any situation. You reminded me of Mr. Ramaswamy. MACT jurisdiction, in fact, is one which I have exercised very sparingly, and that too not to my liking, except figuring in certain compromising positions at the settlement table. My contribution to this branch of law has been virtually nil. As you rightly said, it is a vicious circle now. Tribunals are a vicious circle. I remember about a top-notcher advocate in that jurisdiction. He had the form, the claim form, typed out, printed forms. And the last clause, last column, which was meant for stating the facts of that particular case, he had one line printed in all the forms. This is a case where the principle of res ipsa loquitur applies. That was printed in his form. He was one of the top notches. Of course, you are right, very vicious circle. And a lot of money involved. Wonderful articulation. Thank you.
Thank you, Justice Ramkumar. Thank you, Justice Ramkumar, sir. Out to you, Justice Ramakrishnan, sir.
Really, I thought that when Vijayaraghavan started the area, I thought that he will go into the legal intricacies that is being faced by the lawyer community and also the victim compensation regime. But in fact, he has gone into the question as to how this is being used and misused, I can say.
Any specific questions you have, please go ahead and ask me. If you have the time and energy to spare, I am ready.
No, not that. Because I also stood in your way because I was an insurance lawyer when I was a lawyer. And also I was an MSCD judge for some time. Thereafter, I become, when I could also, I had the opportunity to deal with MSCD appeals also, because probably the roster Chief Justice probably would have understood that I have worked as an MSCD judge. Also, I had a fast record of insurance lawyer. Probably that may be because this is the area where the social justice, social welfare legislation, how it will not be used in a proper way. If it is used in a proper way, it will always do good for the victim. But it is being misused by some section of lawyers, at least some section of lawyers, and also some section of insurance lawyers also, because they want to be more loyal than the king. Even if the insurance companies are prepared for a reasonable settlement, sometimes they will think that if they interfere and reduce some amount, they think they will be more benefited by getting more cases also. That there is an area where there is always a competition, unhealthy competition, I can say. If it is a proper competition, there will not be any difficulty. But if it is an unhealthy competition comes, and unfortunately, even courts are also, when we are interpreting the provisions, they forget about the principle of umeribe fidi.
Yes.
That is how you are pay and recover.
Yes.
We know most of the owners, even if they breach to the tilt or breach for the, at the topmost, you can be able to prove that it is a breach, known breach. Then also probably ultimately you will say, pay it, get it. What is a victim is not responsible for it, because you have collected the premium. Your responsibility is a social responsibility, is a, what do you call it, is a compulsory insurance that is intended by the legislature for the purpose of compensating the victim. Your defenses, etc., it is a contract you can sort out somewhere. That is way in which these things were being dealt with. And ultimately the 149(4) has come to the rescue of the victims in such a way that even assuming that the finding is there, because you don't have an insurance, you have defrauded in getting the insurance, and also driving license, fake license have been procured, and you have produced, knowing that it is a fake license, or you are changing the what you call the driver for that purpose, and there is a possibility of collusion between the owner and the victim in filing the claims also. Ultimately, courts think that anyhow accident is accident, met with some injury is suffered, why can't we pay? That attitude also sometimes give room for this is being taken as a speculative business, I can say. Just like a lottery. Whether if you fall down in a house, I used to say, because when I was sitting in the...
Sir, but I can sustain those orders of pay and recovery.
No, in some cases, it may be.
Legally also.
Legally also.
If you read the sections 149, Yes. Sections 149, subclause 3. He wanted me to deal with some legal nuances.
No,
I got
because
an opportunity. I will do
because
that.
what I say
Section
is,
149, subclauses 3 and subclauses 4. Please read them very carefully in the context of...
No, maybe the understanding you did it, or maybe the way in which I understood may be different.
No, what Parliament, in its wisdom or unwisdom, as I argued in one case before the Madras High Court, divided Section 95, Section 96(2), as it stood in 39, differently in 1989 in the in pari materia provisions. While dividing it, they divided in such a way that only for the defense, when the policy is obtained by suppression of material fact or by misrepresentation, insurer can avoid liability in toto. In all other cases where we have the defense to deny liability, we will continue to pay and recover. That is how the language of the law is today. Unfortunately, there is only one judgment of Madras High Court on this. No other High Court has taken up on this. IFCO Tokyo versus Jafar Sadiq. You can Google and find it out.
No, anyhow, personally, I maybe have a different idea about it. But when as a judge, I used to interpret in that way in which you have done. And also see that it being a social welfare legislation, that the victim should not be denied of the benefit of the this thing, because for the fault that has been or breach that has been committed by the owner. Because victim is not a party to that.
Before I forget, for that, what I have suggested is one remedy. See, this pay and recovery awards, there are so many. There are so many awards which are not executed against the owner. It has become just a paper decree of no consequence at all. What I have suggested is, why not IRBA have a website like the banks have for that CIBIL? That is people who take a loan and don't repay, CIBIL. Why not have a website where all the owners against whom such decrees are pending, then refuse them the right to have an insurance in their name when they come for renewal, or insist on settlement of those liabilities, and then only a renewal will be given. It is possible. Nobody has picked up that idea whichever we have given. In CIBIL has got that website. IRDA can have a similar website.
Those are all the things that will not be sorted out, because the public money is being used for this purpose.
That is true.
That is one thing we'll have to find out. Because if it is being done in a proper case, as you said, coming before the court with the crutches, with no disability. I had also an occasion to deal with a matter when I was appearing for the insurance company as a lawyer. Because the amount of settlement was made. He came with the court. Because on seeing this, and he has got a disability certificate issued by an orthopedic surgeon, also with 50% or 60% disability, with a lot of the language that is being used by the doctor in his, which most of us may not be able to understand sometimes, the autonomical difficulties that is being provided therein. And on that basis...
I remember in the context of Justice Davis, see, for instance, in Madras High Court, the assessment of disability is now made only by medical board in the district, on the basis of the Ministry of Social Justice circular dated 1/6/2001. We are trying to implement it.
Vijayaraghavan, there also I got my own this thing. Because one case, because I got a bad experience. That is the reason I say, a matter was referred to, I was doubting the disability certificate given by a doctor. According to me, it is on the higher side. So I referred to a medical board. Unfortunately, that doesn't have the orthopedic surgeon. Somebody else was sitting for these things, because orthopedic disability has to be gone into. Or in a case where neurological, because these people do not have any yardstick for neurological disability being assessed also. So in such cases, when you appoint this thing, I used to write in my order that a person having the knowledge on neurology also must be available for this. Unfortunately, sometimes it may be available, sometimes it not been available. These people are assessing it. To my surprise, the assessment that was made by them were much more than what was given by the orthopedic surgeon who has assessed. I was shocked.
I remember a famous incident that in Life in Court, Louis Nizer, Mr. Shyam, I will send you, I have a digital copy of Life in Court, very rare book out of circulation, Life in Court of Louis Nizer, the Jewish lawyer. In that, he cross-examines a doctor with regard to an insurance claim. and he takes him through a series of fractures which are all fictitious from his figment of his imagination. See, there are two ways of impeaching the evidence of an expert. One, to impeach the expertise or impeach the evidence. He was trying to impeach the expertise of the expert and proved he was an idiot. Now, I was trying in my own way as a junior. I tried it before Justice David Christian. Then he stopped me in the tracks and told me, do you need to prove that this man is an idiot? If he was not an idiot, he will not be coming and giving and practicing in the MACT. He will have his practice outside in hospital dispensaries. Now, please don't drive these fellows out by cross-examining them at length. We need their evidence to conclude. I need their evidence to pass an award. So I will discount the value of this evidence. So I will treat them as only witnesses for the purpose of necessity for my award, and no more than that, and not as experts. So ever since I started cross-examining also these people.
So these are all the areas where there is a vicious circle always there. So courts are sometimes without proper aid, I can say, as to assess what is real nature of injury that has been sustained, and what is the nature of disability, and how far it has impact on his employment aspects. So those are all the areas where we will have to have our own assessment, that maybe some speculation is there for the purpose of assessment, etc.
An element of subjectivity is
that is always
inevitable.
There. And also, as a judge, now the Supreme Court has said even for a housewife, you will have to have a amount to be fixed for as a monthly income. As a judge, I was doing it. Even as a lawyer, when I was sitting for the settlement, I used to say, don't say that the housewife is without unemployed. She is doing more.
I can inform you that is what has happened. What Chief Justice A.S. Bobde has done is, he has formed an artificial intelligence committee under Justice L. Nageswar Rao. Justice Kannan is a member. Justice R.C. Chavan of Bombay retired is a member. And there are a few other members, and they have roped in others also. They are trying to create a template by which there will be algorithms which will fix the compensation payable. For instance, in California now, bail orders are passed by AI, resort to AI. The courts are not fixing the bail amount or anything like that, or whether parole should be given. AI resort is being, because it has got a big data has gone into it. I think once that AI route comes, I think we can streamline the whole thing and simply award like the moment an accident made. South Africa, they have that system. The moment an accident occurs, within 15 days, the compensation is paid on a fixed basis.
And not only that, even foreign countries, they are not going to the court at all. The insurance companies and they are reaching the people and assessing the evidence.
Insurance coverage is built into the petrol.
So these are all the areas where if everything goes on integrity basis, nothing fails. But if you use the unethical method by which these things can be done, things may be bad also. So that reflects everywhere. So anyhow, it's a good eye-opener as to how an MACT cases will have to be dealt with. Thank you very much, Mr. Vijayaraghavan.
Thank you, Justice Ramashan sir. K. Vijayaraghavan sir, your comments.
Vijayaraghavan sir, I really bow down to you, both for the lucid manner in which you have described everything. I come from the aviation field. Motor vehicles is not part of my life. But in our thing, we normally go by insurance goes by the principle of actual damages. But in the aviation field, by virtue of the Montreal Convention, it is fixed at 1 lakh SDRs. SDR is a special drawing rights issued by the International Monetary Fund and normally linked to the value of the dollar. Now, Kerala High Court, in its wisdom, for the Mangalore crash, Kerala High Court granted SDR, minimum of 1 lakh SDR, which which Air India went into appeal before the Bombay High Court. I mean, it was a path-breaking judgment from the Kerala High Court because they went away from the principle of actual damages and came down to the minimum laid down in the Montreal Convention, which nobody was aware. Aviation being a very different field, not everybody is aware with the norms of the aviation field. And luckily, there is a gentleman called Yashwant Shenoy, an advocate by practice, and he took it up. It went right up to the Supreme Court, where the Supreme Court enhanced 75 lakhs, which was the minimum decided by the Honorable High Court in Kerala. It went up to 7.95 crores plus 9% interest. You see, so ultimately, it is the judges who will have to come up and think rationally and give the compensation based on actual facts. I mean, as you said, yes, there are lawyers who will go for and against this kind of thing, and there are a lot of misrepresentations happening. But at the end of the day, when I come to court, I am looking at which is the temple of justice. I'm looking at the God sitting on the bench. And it is for that gentleman on the bench to give and do justice in the manner it is supposed to be dispensed, and not get carried away either by the information or by the misinformation. You see, and it becomes very difficult for us to adjudicate before the God of justice there, is because even the judges are not well versed with certain norms in the aviation field. And it becomes really difficult. I was arguing one case myself before Justice Wajivdar, who later on retired as the Chief Justice of the Punjab and Haryana High Court. He asked me a simple question. He's telling me, Mr. Rao, you're telling me you fly from Bombay, you reach New York in 16 hours, and then you say you want mandatory rest of 48 hours. Saying, what is the justification for this? I said, sir, you are only looking at one aspect, is 14 hours flying, working, and 48 hours rest. But you forget that when I leave Bombay, my stomach time or my body clock is at breakfast time. And when I land into New York, my body clock has again gone back after 12 hours, it's come back to breakfast time. But my body clock will be at dinner time. So I'll be sleeping. My body clock, even though it is 6 o'clock in the morning in New York, it will not allow me to enjoy breakfast because it is gearing to sleep. And I have to recuperate from the time zones. And I've crossed practically 11 time zones, which is very rare. So he then understood and he said, yes, I appreciate how you explained and put it. And he said, don't. And in fact, he said, say, why don't we judges also get the same rest? Like I come on the bench today and for 2 days I can take an off. I said, sir, that it is up to you. You are the God of justice. So you can decide what you want for yourself. So he laughed. He said, Mr. Rao, don't take it amiss. It was a repartee. You know, it is nice when you have judges who are willing to listen to you, understand what we are trying to say, and get. Like that is why now today the DGC has now come up with a provision called window of cardiac load, WOCL. It now is measuring your body clock. You see, it is whatever be the human body, between 3 to 5, whatever be your rest, you will still be bound to want to sleep or rest. The body will automatically go to sleep. So that has to be factored in when you decide the rest or the mode of things. Anyway, sir, I won't take you away from the main subject.
Contextually, I was just reading the other day about artificial intelligence, where it says nowadays the pilots are not handling the 737 or Boeings as much as they used to physically handle before.
I agree
it's
with
all
you,
autopilot.
I agree
Therefore,
with you,
the accidents are far too many because they don't know how to handle if a mishap occurs.
No, so that is why. So now I'll come back. Since you mentioned it, sir, the 737 crashes that took place, the 737 MAX, artificial intelligence was overriding the physical intelligence. And that is where the reaction time is just 15 seconds. Sir, if you go by the graph of accidents in the aviation industry, they only happen in 2 stages, either at takeoff or at landing. It is never on flight. And that is the crucial area, and that is the crucial point for the pilot. Artificial intelligence, yes, sir. Later, like everybody's trying to adapt to the artificial intelligence, but you have to understand one thing, like our pilots or the senior most pilots are not that akin to artificial intelligence or do not adapt very fast to it. It takes some time, but then everything that goes on, the reactive time is what is to be considered. That is why in air accident, it becomes very easy because the pilot is dead. We can say it was pilot error, close the chapter, and move on. But that would not be the fact, sir. Because there are various factors that need to be considered when an air accident takes place. Because the machine, the human element, the reaction and interactions between the
Southwest in America has withdrawn 737 citing this.
Yes, sir. All over the world. Even India has withdrawn, sir. Even India has withdrawn, but Boeing is now come up with saying that we have amended that thing and we have rectified the situation, so allow it to fly. So the 777 Max will come, 737 Max will come back to flying very soon. So, but like I said, sir, artificial intelligence on ground is very, very easy. You can rectify the mistake, but in the air, if there's a mistake, sir, there are practically hundreds of lives at stake. So we have to be very circumspect to introduce both. Like the Airbus was the first one that came fly-by-wire.
Mr. Shyam, I don't know if you had a session on the aviation.
We should definitely have one. We should definitely have one.
Yeah, because there's so much. It's such a fascinating field.
Absolutely, sir. We will arrange one, and I
both
think
the factual and legal
will take the lead.
No, sir. I'll try and get you aviation experts, sir, who are much senior with me.
You can go ahead and lecture us, sir.
No, it's I am, but I have got seniors who have got much more experience, sir. Like today, the accident investigation board is a disaster in India, sir. If you take for the aviation thing, it's a disaster. I mean, my DGCA, which is the regulator, I have people who have never worked on an aircraft. Either as an engineer on ground or as a pilot on board, they take on deputation from everywhere. That man comes for 3 years.
That's what Shyam says, sir. We have defense ministers who don't know the difference between mortar and mortar, gun and howitzer, gorilla and guerrilla. Most of them look like the farmer. That's what Shyam says.
But sir, that is the bane.
Yes, sir. Yeah, thank you, sir. Vipin Nair, please. Yeah, not audible.
Vipin, we can't hear you.
Unmuted. You have to unmute.
Yeah.
Yes.
No, still unable to hear you.
Okay now?
Yeah, absolutely.
Yeah.
So I was saying a session with Vijayaraghavan, sir, you need minimum 3 hours because he will talk to you on cricket. He's written a book on constitutional law. He's written a book on Sam Manekshaw. We've been friends for the last 25 years. Every day he never ceases to amaze. So more power to him. And
don't inflict them with another lecture like this.
No, I'm saying we should all sit down. So anyway, great having all of you here. And congrats again, Shyam. It's a great feature of 200.
Yeah. See, that's what I want to tell Mr. Shyam. Don't leave this. I mean, even if you can't do it on a weekly basis, I think on a monthly basis, at least you should. It's a real boon to those.
And I think today we are missing Justice Soumya Jalu, who's in different pastures today.
He's
but
traveling. I just called him before the session. He's traveling. He's unable to come.
We missed him.
Webinars and all, it should come to stay.
Absolutely, sir. Thank you, Vipin.
Take care.
We have Girdhar, sir. Yeah, Girdhar, sir.
Hello.
Hello, sir.
It's wonderful to listen again to my dear friend Vijayaraghavan, whom I hear very often since we practice in the Madras High Court. I have no questions to him because I am a novice in the field of motor accidents law. What I have learned about that is from Vijayaraghavan himself, and I had the good fortune of purchasing his book, which we often refer because recently we've been made the counsel for New India Assurance. It was an illuminating lecture, and I endorse the sentiments of everyone here about his knowledge, expertise, and the flair and humor with which he narrates the law, mixed with a lot of personal anecdotes. Thank you, Vijayaraghavan.
Thank you.
That you spared so much time, Giridharan, I'm surprised.
Shyam is known to me. Shyam is very enthusiastic person in spreading knowledge of law among lawyers and judges.
Yes.
We need very much. We stop learning once we come to the profession, thanks to people.
No, that's what yesterday I was reading from Adam Grant. He said, when you talk like you are always right. When you are listening, listen as you are always wrong.
Yeah, good philosophy.
Sir, thank you, Girdhar sir. And as we come to the end of the 196th session, tomorrow there is a change in timing of our session. Please note it is 5 o'clock and it's not 5:30. And tomorrow we have a panel discussion on making the shift to institutional arbitration, feasibility and the way forward. The panelists are Honorable Mr. Justice Rajiv Shadkar of the Delhi High Court and Honorable Thiru Justice M. Sundar of the Madras High Court. And the moderator will be Kotla Harshvardhan Advocate. So tomorrow we will be on the topic, making the shift to institutional arbitration, feasibility and the way forward. And today, sir, in the 196th session, Vijayaraghavan sir, first let me thank Somayajulu sir for introducing you to this platform. And
why the audio is...
And every morning, I cherish the messages you send and especially the cartoons and all those things. I am sure that Vipin and I will be having a full, collection of it. And now I have it and every day I look forward to, not just reading it, relishing it, sir. Thank you very much for that.
Thank you so much.
We are privileged with the presence today, sir. And thank you, Justice Ramkumar, sir, and Justice Ramushan, sir, for your valuable presence and inputs. And all of you wonderful participants for being part and parcel of this 196th session. So till we meet again tomorrow in the 197th session, please do take care and stay safe. Thank you.